Hello everyone, I'm Cristina Fasone, Associate Professor of Comparative Public Law at Luis University in Rome, and one of the editors of the blog and journal Diritti Comparati. It's a great pleasure to have with us today Professor Bruno De Witte, who has kindly accepted to be interviewed. Professor Bruno De Witte is a Professor of European Union Law at Maastricht University in the Netherlands, where he has been the co-director of the Maastricht Center for European Law and is part-time fellow of the Robert Schuman Center at the European University Institute in Florence, where he has previously been from 2000 until 2010, professor of EU law and co-director of the Academy of European Law. Professor Bruno De Witte is an international renowned scholar, a leading scholar in the field of European constitutional law, with many fields of research covered. And I will just mention a few of them. For example, constitutional reform and treaty revision in the European Union, relations between international, European and national law, protection of fundamental rights in Europe, the internal market law, decision-making and legal instruments of EU law, and also rights of minorities, including language law and cultural diversity. The first question I would like to ask, thanking you very much again for having accepted the invitation, has to do with a topic you have covered in many recent publications also, related to the management of the crises and emergencies in EU law. And this includes also the European response to the pandemic, which has been the object of an intense discussion and also different views amongst legal scholars. What are, in your view, the main evidences that we can draw from your analysis on the European management of the crisis and the pandemic, and what lessons can be drawn for comparative constitutional law, looking at the experience of the EU?
Thank you, first of all, for your introduction, Cristina. It's a pleasure to engage in this conversation. To come to your question, I think that if we look at the general literature in European studies, let's say in political science, there's been a lot written on crisis and European integration in recent years. Of course, starting with the euro crisis, sovereign debt crisis, but then we've had all sorts of crises, as we all know. The migration crisis, Brexit, COVID, Ukraine now. So it's like a constant flow. Now, if we look at the legal literature, which is our field, I think there's been two ways of dealing with this. One way is to look at the legal tools available to the European Union to deal with crises and emergencies. So if you want here, one looks at constitutional law as instrumental, constitutional law as providing the instruments that to allow the EU to deal with crisis. And there's another kind of approach in law, which is to look at the impact of the crisis on the constitutional integrity of the European Union legal order, where the emphasis is more on the role of constitutional law as a constraint on public policies. Now, I think that most of the legal literature has been interested in the latter approach, namely in seeing to what extent crisis and crisis measures have affected the constitutional integrity of the EU legal system. For example, people have looked at the way in which the competences of the European Union have been stretched to deal with crisis, and that the legal basis in the treaties have been used for things which were not meant to be, to be done by the EU. Or people have looked at shifts in the institutional balance, strengthening the intergovernmental institutions over the supranational or vice versa. And of course, also on the impact of crisis on fundamental rights, especially the austerity measures which were involved in dealing with the euro crisis. So there's a whole strand of legal literature on this, which is important and to which I contributed in part. But there's another, the other strand is something which I've been interested in recent years, and that is to look at the legal tools provided to the Union to deal with crises, emergencies, and in general with common problems. So my interest here is on this question of what you could call the capacity to act in the common interests of the European Union. And that is something that strikes me, is that in recent years, we have had so many, major problems that clearly had a sort of Europe-wide dimension, or sometimes a global dimension, including climate change, but also migration and refugees, the COVID crisis, etc. And so the capacity to act for the Union, in a sense, is the most fundamental value that there is. If you look at the Treaty on the European Union, many people now look at Article 2, rightly, Article 2, which is about the fundamental values of the integration process. But Article 2 is preceded by Article 1, which says that the member states have created a union that should deal with, to which they confer competences to attain objectives which they have in common. So the fundamental importance and value of the Union is that it should enable the states of Europe to deal in common with certain things. And that's why they've created the European Union. And the EU should be able to do so. And so, given that perspective, what I've looked at in some of my recent writing, first dealing with the consequences of the Euro crisis, but then especially with the response to the COVID crisis, is the extent to which the European Union has used the existing competences and the existing decision-making mechanisms in sometimes innovative and creative ways in order to be able to effectively deal with those crises. And there's been a bit of a controversy about that, because some other scholars have said, well, there's been massive violations of existing EU law. There's been no respect for the constitutional integrity. I tend to side on the other side, of saying we have to allow for creative thinking here, given the fact that, EU law is what it is, the treaties are what they are. We have these common problems. We do recognize that they need common solutions, so the European Union must have the capacity to act. And so there are some emergency competences or more general legal bases which have been used in this context. And that's what I've tried to look at, especially when examining the NGU program, the response of the European Union to the economic consequences of COVID. So sorry for this lengthy response.
No, that's perfectly fine and super interesting. Here the reference is, of course, to an article recently appeared in the Common Market Law Review, in which you deal at length with all the various legal tools adopted in reaction to the pandemic in the framework of Next Generation EU and beyond that. The issue of constitutional integrity and capacity to act effectiveness is something that is very present also in the domestic constitutional law debate. For example, when looking at the capacity of constitutions to react to crisis, and then the immediate point of reference is to constitutional amendments. But then when it comes to the EU, instead we face some hurdles, some difficulties also due to the treaty revision procedures, which appears to be sort of taboo from a political perspective, the capacity to reform those treaties. And from a legal perspective, what do you think are the main challenges ahead in relation to treaty change, if they are needed? And what is the relevance, the significance here of national constitutional limitations to European treaty change?
Yes, I think this discussion is related to what we discussed before, in the sense that the legal creativity that has been displayed in recent years to deal with some of these crises is also connected to the fact that it's so difficult to modify the treaties. So if it were easier to modify the European treaties, then one could say, okay, there's a new challenge here. For example, there's a war in Ukraine. We need to equip the European Union with new powers and capacities to deal with this. Let's modify the treaties. But as we know, this has become virtually impossible, since the old rule that dates back to the time when there were only 6 member states of the European community, namely that all states have to agree with revisions of the existing treaties. That rule is still in place, meaning that we today have 27 states that have to agree with changes of the treaties, all of them. And it's not just 27 states. We in fact have 54 veto moments for any treaty revision, but because not only do these 27 governments have to agree during negotiations, but after that, there's the need for the individual ratification of treaty amendments in each of the 27 countries. And what we see there is an increasing number of so-called veto players. So an increasing number of actors at the national level who can, stop a treaty amendment from entering into force. So we have 54 moments or 54 ways in which things can go wrong with treaty revision. So that has become an almost impossible enterprise. And we can see that now that since the Treaty of Lisbon, which was of course a very painful process to put it in place, since then, most governments are extremely reluctant to even think about treaty revision, saying, this we can't do this. So we have to find other ways of dealing with problems. So this is not normal, okay? So if we compare this with constitutional change and procedures for constitutional change in countries, in states, there's not a single country where things are so difficult. Or let's say there might be some, like the United States is also notorious for having very difficult constitutional amendment procedures, but at least they have a constitution which says very little. It's a very short one. The problem with the European Union, with its constitution, its so-called constitution, is that it's not only very difficult to change, but it's also very long and detailed. It's 500 articles altogether, including many very detailed provisions, which in practice can hinder the conduct of public policies. So the combination of the two, the fact that you have such difficult political circumstances for changing the treaties, and the fact that there's so much detail in the treaties, leads to a really difficult situation. And I think the time has come, that's my personal conviction, to think of abandoning the unanimity rule even for treaty revision. And this is, of course, very much taboo, in the sense that, governments are not ready yet to contemplate this possibility. But I think that in the long run, and certainly if we get even additional new member states in the future, we can't go on like this. And I would add something. I would add that from the national interest perspective, let's say from the perspective of the national interest of Italy or the Netherlands or whatever country, abandoning unanimity is actually useful, because the chances that your country will be in the sort of super majority that you will still need, to change the treaties, the chances that you will be part of that super majority are so much higher than the chances that you will be the 1 or 2 countries that try to stop treaty revision, that it is actually in the national interests of all countries, or let's say of most countries, to take that step and to say we can't go on with unanimity. Now, let me add one thing, which is related to what you said about national constitutions. If we would ever take that step, if we would move to a situation where the treaties, or at least large part of the treaties, can be modified by some kind of supermajority of states, that might require amendments also of some national constitutions. Now, that's, of course, a matter which depends a lot on the way national constitutions not only are formulated, but are also interpreted. So would national constitutions allow for the ratification of a treaty that does away from the unanimity requirement for future treaty amendments? That's the question, no? I think in many countries, yes, because, let's say the Netherlands is a party to many treaties establishing international organizations, which can be modified by, majority votes and without necessary ratification by the Netherlands. So it would not be a constitutional revolution. But in some countries, maybe in Germany or in other countries, this might be seen as a constitutional revolution, or at least something that would require a specific amendment of the constitution to allow for the EU to move forward in the future in a way which is no longer under the control of each member state.
Thanks. This is extremely interesting because it seems that wherever we look at, there are problems. So even though we are able to overcome unanimity, there might still be contentious points to address at national constitutional level, not easy to reconcile with the common view of the others, possibly. Thanks a lot. I would now like to shift a little bit the perspective to maybe cover another topic that has been the subject of your scholarship, of your publications, that is minorities, in particular linguistic minorities. And I would like to ask for your assessment of what is the state of the art of the protection of linguistic minorities between the EU and the member states, looking at the last few years. What is the situation? What are the potential avenues for improvement and the weaknesses of the system?
Yes, so here the connection with what we've discussed previously is not at all evident. And so the connection is a personal one. It's just the fact that I happen to have worked also on questions of minority protection, first of all in my own doctoral thesis a long time ago, but also after that I have continued alongside my work on EU constitutional law to also work on issues of, minority protection, language law, cultural diversity, almost as a hobby a little bit, but as very much as a side stream. Now, there are connections, of course. There are some connections between EU law, EU constitutional law, and the questions of cultural diversity and minorities. But they're not very strong in the sense that, as you know, what the European Union treaties say about this is that the EU should respect cultural diversity. That's the essential statement that you find in the treaties in several places, meaning that the European Union should basically respect the way in which each member state deals with its own cultural diversity. That's what it means in practice. So the treaties doesn't say the European Union should protect cultural diversity. That is to say, the European Union should take an active role in protecting minorities. Not at all. I think the position of the treaty text, as it has been interpreted, over the years, is to say, this is one area which is basically left to the member states to decide. They're the ones who decide how to deal with diversity within the country, how to accommodate cultural and linguistic diversity. And as we all know, the practices of the member states are very diverse in this respect, ranging between countries that insist on, on the fact that minorities do not exist in the country, cannot legally exist, like in France, and countries where, there's a very, very complex way in which constitutional law actually deals with cultural diversity, as for example in Spain, but there are many other countries. So the practices in national constitutional law are very diverse, and EU law doesn't much interfere with that. So the only interference happens whenever national regimes of protecting, minorities or cultural diversity clash with the internal market freedoms. So we've had some cases of the Court of Justice on that, but it's very minor. It's rather marginal. And the Court of Justice on the whole tends to be quite respectful of the policy choices made by the member states. Now, that doesn't mean that countries are completely free to deal with minorities and with minority cultures in the way they want. But the constraints on member states are not so much based on EU law, but rather on international human rights law and on the specific minority treaties adopted within the context of the Council of Europe. As you know, the Council of Europe is the poor relative of the European Union. You know, there's very little that the Council of Europe can do, is left to do alongside the vast activity of the European Union. But this is one area in which I think the Council of Europe is still the leading organization in Europe. The area of protection of human rights, of course, with the European Court of Human Rights, but also the protection of minorities, where you have these interesting treaties to which many European countries are parties, with an interesting monitoring mechanism also that tries to bring states to get closer to convergence, one could say, in the way they recognize and deal with minorities. So this is also interesting in showing the pluralism of European integration, is that the European Union is not the only game in town, that member states still have other forms of cooperation, even within the European context, such as the Council of Europe. Thanks.
Thanks very much. These are inspiring thoughts and show us also the variety and diversity of topics you have managed to cover, but at the same time also the connection they have. And maybe more broadly speaking, also for our audience, which is composed of European but also comparative lawyers, I wanted to ask you, what is your view on the role of comparative law in European legal studies in general? Also looking a little bit at the dimension that the EUI tried to promote from the very beginning with the legacy of Cappelletti and others. So what do you think is the role that this field, comparative law, can play in European legal matters?
Well, it's an essential role, and it's of course related to the nature of the European Union. The European Union is still an international organization. It's still an organization of the member states. They're still the ones who have, who are in charge. And although I have argued before in our conversation here that, member states should accept more restrictions of their sovereignty in order to make the EU effective, to keep the European Union being effective, the EU is still a creature of the member states. And because of that, the constitutional law, the public law of the member states is of essential importance in understanding the European Union and the way it operates. So constitutional law is there ex ante, in the sense that constitutional law constrains the way in which the European Union operates, because constitutional law defines the way the member state governments operate within the EU context, the conditions under which they can act, the controls to which they are subject in their national legal systems. And of course, national public law is there on the other side. Once public policies have been developed at the European level, they have to be applied by the member states, as we all know. And so the European Union doesn't have its own administration on the ground. It depends on the member states. And therefore, understanding at least the basics of how member states' constitutional and administrative law works is essential to understand the operation of the European Union. Now, I'm not saying that every scholar of EU law should be a specialist of comparative public law, but it helps, to know at least the public law of one or two of the member states in order to be able to put things in perspective. So I think comparative law is important. It's there because it's the context, it's the legal environment within which the European Union operates.
Thanks very much. So we always need to see this double dimension that to some extent shapes the functioning of the European Union, without forgetting also the national dimension, the reference to, common constitutional traditions, whatever the content is. And And now for the maybe younger scholars and researchers, I wanted to ask maybe for your advice on which topic would you suggest for young researchers to engage with, to explore in the field of European and comparative constitutional law according to the approach you have devised?
There's so much, of course. There's so much going on. So I think if one is interested in European law or in comparative constitutional law, there's so much going on these days. It hasn't always been like that. When I started doing my own doctoral studies, as I mentioned before, I decided to work on the protection of minorities. So my work was one of comparative constitutional law and international law, but not EU law, because at that time, not much was happening in the European communities at the time. These days, so much is going on. Now, much of it is not very positive. There's lots of problems going on. But for lawyers, there's a lot of interest here. I mean, look around. There's so much to look at. The one advice, of course, is for young scholars is to try not to follow the herd, not to be like sheep, to all run in the same direction. We see that, of course. We see these fashions, is that suddenly there's a new topic and everybody wants to write about it. But that's difficult, because if 10 of your colleagues have already written about, let's say, the rule of law crisis in Poland, to give just one example, then it's difficult if you're number 11 to add anything, original or new about it. So it's also important to think about things which not everybody is writing about at the same time. To think there's lots of interesting developments, and to think carefully about what one would like to work on. You need to be interested in what you look at, and also what is original. What has added value compared to what others have been doing. Of course, there are topics which require the sustained attention of many people, but there's many things happening at the same time. If you think just now, these months we have the Ukraine war and the challenges that it raises for EU external relations, for its common defense policy. New developments in migration law with the temporary protection directive, which is implemented for Ukrainian refugees. But at the same time, we have the discussions on the implementation of the Green Deal, the legislative package that the Commission has put forward last year, which is now being discussed in Parliament and Council. We have the rule of law discussion and debate in Poland and Hungary. We have the digital transformation. We have the question of how the next generation EU program is going to be implemented in the years to come in the various countries, and what the future will be for the EU's fiscal capacity. So there's so many things going on at the same time, so that young scholars are spoiled for choice, I would say. There's enough things to look at, and lawyers are always needed. That's the problem, and the nice thing in the sense that legal scholars do not have to invent their subject, because their subject is there. The law is there, because public policies have to be transformed into legal rules. There's no other ways. And so there's always going to be work for legal scholars.
Thanks. That's reassuring, even though your advice to think carefully, of maybe not necessarily mainstream themes, and to be selective is, I think, very important for young scholars. And now, to conclude, I wanted to ask you, what are you currently working on, or what are your plans for future research themes you want to cover, so that we are ready then and eager to read your next publications on the topic?
Well, as with everybody, there's some short-term, smaller projects, and there are longer-term, longer projects. You know, that's I think what how most of us are working. So in the short run, I will write some smaller pieces on things like the role of the European Council, EU crisis law, evolutions also in the application of the Charter of Fundamental Rights. But in the longer run, one of the projects I have, but I cannot yet guarantee that this will lead to a substantial piece of research, is the topic of our first dialogue here, namely this issue of the legal, let's say the legal conditions for the EU's capacity to act and to deal with common problems. So the question of how the European Union, the design of the European Union's constitution affects its capacity to act and to deal with common problems in both positive and negative ways. The way in which the treaties allow for many things to happen, you know, if they're creatively interpreted, but the way in which the treaties also constrain the action of the EU. Sometimes in useful ways. It's important, of course, that public policies are being constrained by constitutional values, such as protection of rights, but also sometimes in not so useful ways. Think of the unanimity rule in decision-making in the EU. So it's a very broad topic, but it's a topic on which I gave a course at the EUI's Academy of European Law a few summers ago, and which I still need to write down. So maybe that is going to be a midterm project of mine, to try to write a little book along those lines.
Very, very interesting. So let's see, looking forward to that. And to this very important dimension of the tension between constraints in constitutional law, European constitutional law, and instead capacity to develop more in line with the societal needs. Maybe that's an inherent tension in constitutionalism, whatever is the level of government we look at, really.
Exactly.
So,
yeah.
Thanks very much for taking some time to share your thoughts with us. That was really insightful for me. I've learned a lot. We will certainly stay in touch. And thanks once again.
You're very welcome. Thanks a lot, Cristina.